The 14th Amendment is not safe, and it never was. Hey, I'm Tad Stoermer. I'm a visiting scholar at the University of Southern Denmark. I'm still a lecturer at Johns Hopkins, and I'm the author of the forthcoming A Resistance History of the United States. Last weekend, I saw a lot of people breathing a little easier after the Supreme Court's ruling on nationwide injunctions on Friday. Lawyers, commentators, they rushed to clarify. This was procedural, they said. It didn't touch the merits of birthright citizenship, so don't panic. And they're right. Technically. But the court's move, precisely because it didn't settle the substantive question, is telling. This court knows exactly how to leave the door open, especially when it wants a few more lower court rulings to line up with the outcome it and this regime prefers. This was not restraint, it was staging. So yeah, the ruling doesn't overturn the 14th Amendment, of course not, but it cleared a path for a more targeted and more comprehensive challenge, designed to chip away at it from below before they deliver the major blow after they come back in October. This regime has already promised to walk that path. They're telling us plainly that birthright citizenship is absolutely on the table. But what's frustrating to me, got to get to that, is the number of people that still cling to the idea that the Constitution's language, especially the 14th Amendment, is somehow, what, self-executing? That it has to mean what it looks like it means to you. But that's not how this works, folks. That's never been how this works. The modern understanding of the 14th Amendment, equal protection, birthright, citizenship, due process, is just that. It's modern. For decades after its ratification, the courts twisted and narrowed its meaning even when the people who wrote it were still alive, telling them, no, it didn't mean that. The court said something else. The 14th Amendment that says anyone born in the United States is a citizen was used to exclude Chinese immigrants, sidestep indigenous authority, and rationalize racial segregation. Yeah, Wong Kim Ark, 1898, 30 years after the 14th Amendment was passed, it did uphold birthright citizenship 30 years later. But even that was a bitterly contested decision, and it was bitterly contested for Wong Kim Ark, who got arrested a couple of decades later. It didn't mean much in practice until the 1920s, and it wasn't until the 1950s and 1960s that courts began to build anything like the modern rights framework people now think of as settled. That's less than a lifetime ago for a lot of people. So it's not any kind of constitutional bedrock. That's not how the U.S. Constitution works. It's precedent. And as we know now, and as this court has made a pro sport out of, precedent can just be reversed. Meh. And if you want to understand how fragile even the idea of birthright citizenship has always been, especially for Black Americans, read my once and future colleague Martha Jones' Birthright Citizens. It's the definitive account of how free Black people in Antebellum Baltimore fought for the rights that most white Americans still think were settled by statute or by amendment. They weren't. They had to be claimed and defended and redefined long before the 14th Amendment ever existed. And that fight isn't over. And the court knows that. And they're happy to open up a new front. In fact, they're counting on the public not knowing that. They'll claim, because they're laying this groundwork, they'll claim they're restoring the Constitution's original meaning. They'll quote early 19th century opinions. They'll reach back to, of course, the founders who made sharp distinctions between citizens, white, male, property-owning patriots, and inhabitants, everyone else. This is very clear in the founding documents. This is very clear in the work of David Ramsey. This is very clear in the first citizenship laws passed by the first federal Congress. Stephen Miller has already deployed that exact logic. True citizenship belongs only to those who inherited it through the Revolution or earned it by naturalization, which was, for most of U.S. history, established by those patriots in the first federal Congress, limited to free white persons, explicitly excluding Black people and indigenous people from citizenship forever. That long road is a different story, which leads us to the 14th Amendment being necessary in the first place. And no, this isn't just about Stephen Miller or this court. The real danger is the Constitution, is the structure. The Constitution, Article 3, gives the court no real guardrails. It doesn't define what rights mean. It doesn't force anyone to interpret it in good faith or give any kind of guidance about that. It leaves all of that up to the people in charge. American governance is just a risky trust exercise. And so when the people change, so does the meaning of the Constitution. We learned that with Dobbs 3 years ago. We saw what happens when an entire generation assumes precedent will hold and then it doesn't, no matter what the nominees to that court say in front of confirmation hearings. The same thing's happening now. Birthright citizenship is not guaranteed by some constitutional magic. It's guaranteed by 5 justices and 1 more challenge. The Constitution has never protected the people. It has always served the priorities of those interpreting it. So don't be reassured by procedural rulings. Be alarmed by what they make possible, and stop pretending the Constitution can't go sideways. It already has, many times before. If we want to resist what's coming, here's a resistance dispatch of the day. We have to start by telling the truth about the system we're in. Because the words on the page don't protect anyone. The people in power do, or they don't. And right now, they don't. And tomorrow's not looking too good either.